know that going to court is not the only method of resolving disputes in business? I'm sure your next question would be, are there other alternatives? Hello and welcome to the Lex-Praxis channel. In today's video, I will show you effective and smarter methods of resolving disputes in business without stepping into the courtroom. Of course, in business, disputes or conflicts are inevitable, whether they arise from either contract, payment, or partnership. However, one thing you need to carefully pay attention to is how you choose to resolve those conflicts, which can either protect your business or damage it completely. In Nigeria, a lot of persons believe that going to court is the only method of resolving disputes when they arise in business. Fortunately, there are other less expensive, faster, and more strategic approach of resolving disputes in business amicably, and also still help to maintain long-term relationship with the other parties. Your next question will be, what are these alternative dispute resolution? Basically, in Nigeria, there are two effective alternative dispute resolution methods. The first one is arbitration, and the second one is mediation. Now, I'll start with mediation. In mediation, there is a neutral third party called a mediator. Now, what a mediator does in resolving disputes in business is that it helps the parties to communicate better and also help them to reach a common ground. Unlike a judge in a court proceedings, a mediator does not impose its decision on the parties. Rather, what a mediator does is that it guides the parties' conversation and help them to reach voluntarily or mutually acceptable agreements. And it's particularly useful when the parties are willing to cooperate, but then they need proper guidance to resolve their differences. One defining feature of this aspect of dispute resolution is that it ensures confidentiality, meaning that discussions are conducted in private and sensitive information of the parties are kept out of the public domain. Another powerful dispute resolution method is arbitration. Arbitration is a bit more structured, but I'm going to simplify it for you to have a better understanding. So just like mediation, arbitration also have a neutral third party called an arbitrator who listens to the party and makes decision which is usually binding on the party. Arbitration is mostly used in commercial agreements because it is faster than litigation or than going to court, and it allows the parties to choose someone who is an expert in their specific line of business operation. Just like mediation, arbitration also ensures flexibility, also ensures flexible confidentiality. One defining feature of this aspect of dispute resolution is that decisions reached under this method of dispute resolution is enforceable under the law, making the parties to have certainties, making the parties involved to take the process serious in all the in the entire proceeding. Now, let me share a simple insight with you. Smart businesses do not rush to courts to settle their dispute, to settle their business disputes. Instead, they explore the best options first. And one of the smartest ways to achieve this is to engage a lawyer who has an expert knowledge in alternative dispute resolution. This is because it is only a lawyer that can use their expertise to assess the nature of the dispute and recommend the most appropriate method, whether it is arbitration or mediation. And also, a lawyer helps the client to understand the legal implication of each of these alternative dispute resolution. I hope you found this discussion helpful. Do well to like, share, and subscribe to the Lex-Praxis channel. And for more inquiries to decide on the best option to resolve your business dispute, feel free to reach out to us through our contact details on the screen. Thanks for watching and see you in our next video.